Struggling to pay your child support? Are not receiving any? Need a modification? Has the Department of Revenue filed a case against you? Don't face this alone. If you are dealing with a child support problem, a knowledgeable family law attorney may be able to help you solve it. Let us help so you can focus on being the best parent you can be. Stress less, choose more. Hello, everybody. This is Conti Smith. I hope everyone is doing well and that they're looking forward to their Thanksgiving weekend. I am I'm a family law attorney in Florida, specifically in Central Florida, and I am excited to be here to answer more questions about family law and immigration. And Frank, do you want to introduce yourself?
Yes. I am Frank Symphorien, board certified immigration expert, and I have a pleasure of being a good friend of Conti Moore and law school classmates. And obviously, I'm the founder of Symphorien-Saavedra Law, which is an immigration firm here in Orlando, Florida, that specializes only in immigration law.
Awesome. Thank you for joining us. So, Frank, I have received a lot of questions since our last recording. And so I'm going to use this time to answer questions that I have for potential new clients and for clients. So if you don't mind, I have a list of my top 10 questions I want to ask you. Okay? You ready? Are you ready? All right. If my green card is based on marriage, what happens to my immigration status if we divorce?
So it basically depends. I mean, for the most part, if it's based on marriage and you divorce, as long as you already had your green card issued, then you are able, and if you have a 2-year conditional green card, you're able to remove the conditions based on abuse, hardship, or the fact that you married in good faith. Those are the 3 bases upon which you can ask for an exception to the joint filing requirement. Obviously, if you have a 10-year card, then you can just file for citizenship after 5 years, or you can renew your green card after 10 years.
Okay, thank you for that. Next question. Can I still get my 10-year green card if we divorce before my 2-year conditional green card expires?
Yes. And again, this is the same path forward. You can request an exception to the joint filing requirement, which again is based on hardship, abuse, or the fact that you married in good faith. So you can request a 10-year green card, as at any time really after the divorce is filed, if you can prove that your marriage was entered in good faith, or that you were the victim of abuse as a battered spouse or something like that, or that there's extreme hardship to yourself if your 10-year card is not issued.
Okay. Will USCIS deny my case if my spouse withdraws support or refuses to help after we separate?
So the answer is that it depends, as with a lot of lawyer questions, right?
Okay.
But yes and no. I mean, if there was no abuse, if the relationship just ended, your green card is based on your relationship. So if your relationship ends, your green card ends. Okay. Now, Congress created a separate path that allows people that are victims of abuse and that are being, harmed in harm's way to self-petition and request their own green card, even if the spouse withdraws the support. So there is, if the separation is based on abuse, some sort of control, any type of violent situation, either emotional or physical violence, then there may be a path forward where if you file a self-petition as the victim of abuse.
Okay. What evidence do I need to remove conditions on my green card without my spouse?
So again, there's three exceptions. The first one is good faith marriage, which is the most common. So in that one, you're essentially going to require evidence that your marriage was entered into the good faith. So you're going to want bills, pictures, photographs, letters, text messages, videos, audios, support letters, proof of residency, social media. I mean, really anything that puts you and your spouse in the same place, that would essentially work as evidence of your good faith relationship with the spouse. So that's the first one. The second one is abuse. We've discussed this before. So if you're a victim of abuse, whether it's mental, physical type of cruelty, whether it's text messages where he's controlling you, phone records, pictures of harm, police reports, ideally, if you call the police on him because he's abusive, anything that establishes that there's a control relation. Or we talked about before how to develop some of those evidence. Like if you don't have evidence, but maybe you respond to a text and say, well, I don't like how you're threatening to take away my papers. That's uncalled for, and you're developing or creating records of the abuse. Or I don't like how you punch me or you push me or shove me or whatever. Then if the person doesn't respond, that counts as evidence of the abuse. So really anything that establishes, and you could also have witness testimonial, really anything that shows that they're more likely that there's any credible evidence of abuse can work to establish the second exception. There's also a third exception, which is based on hardship. This is a little bit more difficult, and it's very rare that it can be established because the government is pretty strict on it. But if after the marriage, there's some unique circumstances in your life that would cause you severe or extreme hardship, then the government can consider those circumstances. But again, they are very harsh with this last requirement. So usually the best path forward is to establish the good faith nature of the relationship or some form of abuse.
Okay. How does divorce affect a pending I-130 or I-485 application?
So this is kind of the same as the first question. If the applications both are still pending, then and they're both based on a marriage, then the applications disappear once the marriage dissolves. Right. So essentially the I-130 petition would be denied because it requires your husband. It's a joint petition. It's his petition for you. And so it would essentially be denied the minute you divorce automatically as a matter of law, actually.
Oh.
However, if there's a circumstance of abuse, violence, whether emotional or physical, then you do have a window while your residency application is pending, your petition, which is the I-485. In general, if you promptly file the I-360, which is a petition as a victim of abuse, you could potentially keep that I-485 in play and held in abeyance of the government making a determination as to whether you were a legitimate victim of abuse.
Okay.
So,
right.
So there's potentially the two paths it could go.
Okay. Can I file a waiver for my green card if the marriage was real but ended to abuse or extreme cruelty?
Yes, absolutely you can, and we do it, hundreds of times. We've done it hundreds of times. You just need to establish that it's a good faith marriage, that it was real, that it was not for immigration benefits. And if there was abuse, that's an additional factor. It's a separate exception in itself. So there's two different exceptions that you can establish here. You can establish one that the marriage was real, you had a good faith relationship, and two, there was abuse, there was some sort of blackmailing and psychological attack, physical attacks, etc. And you can remove the conditions on your green card that way.
Got it. Does child custody or child support impact immigration status or future applications?
So essentially, no. I mean, there could be some indirect impact, right? So, obviously children always help establish that there's a good faith relationship, right? So if you have a child, usually people don't have children unless they're in good faith relationships. And so it's one of the best evidence. Well, at least at one point, maybe not long term, right? But it means at least for one split second, at least, right? They were in a bona fide relationship, potentially, or at least one of the parties were, right? Sometimes somebody's using the other, but at least one of the parties at some point had to be in a good faith relationship. So it's great evidence. Child support probably doesn't. I don't think either child custody or child support has a direct impact because it's really not relevant for immigration purposes. but it can have an indirect relevancy.
Okay. If my spouse threatens to cancel my papers, can they actually do it? I get this a lot.
So, I mean, the answer is yes. I mean, it is their petition. So they file a petition, and also on top of that petition, they also have to complete what's called an affidavit of support. It's a request to the government saying that they're going to be responsible for you financially. And so, if your green card has not been issued yet, your spouse can write to the government and say, "I want to withdraw my petition and I want to cancel my affidavit of support." So that is a clear yes. However, the law, if you are the victim of abuse, and again, this type of threats, this type of control. I mean, this would be one indicator that potentially there's some sort of emotional abuse, psychological abuse here. And so, if they constantly torment you with this, and they use that your papers as a way to control you and attack you, then potentially, in a lot of cases, I would say probably you likely have a good case of psychological or physical abuse, which would allow you to submit your own papers, basically, right? Submit your own residency application without your spouse's support.
Okay. What rights do I have to stay in the U.S. if I am undocumented and separating from my citizen or resident spouse?
So, essentially the same rights. I mean, again, your spouse has the right to withdraw his petition. They have a right if they don't think, if they no longer want to be married to you, they have a right to petition the government and say, I want to withdraw that sponsorship for you. And they can withdraw the petition and the affidavit of support in which they're agreeing to financially support you, for a prolonged period of time. However, if you are a victim of abuse and there is something extraordinary, something different, right? It's not just a clean breakup where you're like, okay, we're no longer happy. You go your way, I go my way. If it's not that, if there's some sort of threats, control, abuse, psychological, emotional type of abuse.
Financial abuse, does that count?
Financial abuse counts too. Yes. I mean, it's all the factor, totality of the circumstances. And it's any credible evidence that you're the victim of physical or emotional abuse, then you can qualify for a self petition potentially, where you can sponsor yourself to become a permanent resident.
And does living separately count as a red flag for USCIS even before divorce papers are filed?
Yes, absolutely. If you're not living with your spouse, I mean, most spouses live together. So, if you're not living together, it definitely will suggest to the government that this is not a good faith marriage. Now, that's not determinative, right? That's not sufficient in itself. But living separately will be a factor. That's one of the first things that the government looks like. Where do you live? Your driver's license will be requested at the interview. Your spouse's driver's license will be requested at interview. It's important to note, though, that if your spouse is willing to support you and there is no final divorce decree, people don't understand this, and they do this a lot. They'll go to the interview with a spouse, pretend to be together, pretend like everything's fine, but they're ready to get divorced, and then lie to the official. And the official can pull up records that show that you're not living together, right? So one of the first things you want to do is if your spouse, you're having trouble, you're thinking about divorce, you're considering divorce, but you're kind of on good terms, you need to contact an attorney immediately, so that you don't take the wrong approach in going to an interview pretending something that you're not. Because if you pretend to be together, and they catch you, then everything's going down. It's not a good start. However, if you go up there and you say, look, we're having trouble, we're legitimate, we married in good faith, there's no divorce, we're still committed to helping each other, he's committed to helping me through this process, they won't divorce me until it's done. And so, we're going to stick it out until this is done, because we had a legitimate relationship at one point or another. We did not marry for papers. So you can get a residence card even when you're separated from your spouse.
As long as you're honest.
As long as you're honest, it's about how you approach it, right? Now, if your spouse withdraws the petition and you're living separately, or a divorce is final, right? Either one. If the divorce is final, it automatically revokes his petition on your behalf. If he files, if he withdraws the petition, then his action of withdrawing it cancels your process. So if you're having trouble and things are not amicable, and you suspect, and you're not sure what your spouse is doing, you need to meet with an attorney urgently to determine whether there's any potential abuse, whether you have evidence of, if you have been a victim of abuse. Contact an attorney to see if you can file a self-petition to protect yourself.
Awesome. Well, thank you so much for answering the questions that we've been getting a lot from our clients and from potential new clients. You are an amazing immigration attorney. I see you on the news all the time. How can people reach out to you for your services?
Well, the best way to contact us is to call our office or find our website. You can reach us at 407-802-1717. Or you can, contact us through social media or on our website, Symphorien-Saavedra.com. So thank you for that compliment, Conti. And I can't go without saying that you guys are amazing as well. It just, family law is such a difficult and emotional process that, any client that I send to you, it's just refreshing how you can help them find some sort of peace and resolve their situation. And it's great working with you guys because you guys are so great at communicating. So
I appreciate that so much, Frank. If anybody that you know that's watching needs help with a family law issue, please contact our firm at 407-831-0203 or at contimorelaw.com. We come on here every month and we answer questions. And I know that it's helping people because when they call me, they say, I watched your video about this. So, Frank, I cannot thank you enough for taking the time to help answer the questions that I can't as a family law attorney about immigration issues. So thank you, thank you, thank you. I wish you and your family a happy Thanksgiving. To everyone watching, we wish you the best. Have a great holiday and come back and see us next month.
Sounds good. Take care.
Thanks.